We have breaking news tonight in Donald Trump's criminal case in Washington, D.C. This is the coup trial, where Trump is charged with 4 felonies connected to his efforts to steal the 2020 election and stay in power. The judge in that case, Judge Tanya Chutkan, just filed an order responding to Trump's motion asking she recuse herself from the case. Trump actually began demanding Chutkan's refusal within days of his indictment on August 1st, announcing that he had very powerful grounds for his request. Earlier this month, when he filed his motion, the grounds didn't look quite so powerful. His lawyers based the motion on things Judge Chutkan said at hearings for 2 defendants facing sentencing for crimes at the Capitol on January 6th. His lawyers arguing that Judge Chutkan had, quote, suggested President Trump should be prosecuted and imprisoned. Well, in her 20-page response today, Judge Chutkan basically said they were making things up, writing, at the outset, it bears noting the court has never taken the position the defense ascribes to it, that former President Trump should be prosecuted and imprisoned. And the defense does not cite any instance of the court ever uttering those words or anything similar. She goes on. It is the defense, not the court, who has assumed the defendant belongs in that undefined group of people who should face charges. And to extrapolate an announcement of the defendant's guilt from the court's silence is to adopt a hypersensitive, cynical, and suspicious perspective rather than a reasonable one. Defendant's motion for recusal is denied. Shan Wu is a former federal prosecutor who served as counsel to Attorney General Janet Rito, and he joins me now. Shan, maybe we can start before we get into this of just what the standard for recusal is. I imagine it's got to be relatively high, right? I mean, the system works in these sort of random assignments of judges, and generally that you kind of get the judge you get. So what is the bar here?
It's a pretty high bar, Chris. It's the clear and convincing standard, which is actually the next highest to the highest one, which is beyond a reasonable doubt in criminal cases. So it's a very challenging standard. And as you say, it's challenging for good reason, because if you made it very easy, then you would really encourage judge shopping. And that's what the court system does not want to do.
Now, the reasoning here was the argument by Trump's lawyers is they basically zeroed in on things she said at sentencing in 2 other January 6 trials. My understanding is there's actually pretty bedrock Supreme Court precedent on this. And there's a bunch of other cases that they cite in their brief that are judges saying things in public appearances in the press. And Judge Chutkan seems to be focused on saying, look, those are not germane, right? We're talking about what I said at sentencing.
That's exactly right. And the precedent really talks about how judges who are speaking within the courtroom, that speech is particularly scrutinized with a high bar, as opposed to making public pronouncements which might be deemed to be prejudicial. And also the precedent zeroes in on whether the court is speaking about this particular defendant seeking recusal, and she did not address it to Trump's guilt or whether he should be charged. She was addressing arguments made by those defendants trying to lessen their guilt, saying they were influenced by others. So the idea that, as the court sets out in their order, that simply suggesting that the court may have been suggesting that really is very, very far from meeting this kind of standard.
Yeah, we should just to give the context here, right? She's at sentencing for a defendant named Christine Priola, who's found guilty for her role on January 6th. She went inside the Capitol. Her lawyers asked for leniency, arguing that Trump and his inner circle had convinced the election had been stolen. And she writes in her opinion, the court did state the former president was free at the time of Priola's sentence, an undisputed fact upon which Priola had relied for her mitigation argument. But it went no further. It being the court there. I didn't say anything else. The defense purports to detect an inescapable message in what the court did not say, that President Trump is free but should not be. What's interesting here to me is you've got the judge before you. You file a motion that contorts her own statements. Like, she knows the context of what she said. It's a wild thing to do, to try to wrench out of context statements by the very person to whom you were filing the order.
Especially because that's always the person who is the initial finder of fact and law. There is the very person you're trying to recuse. And it's interesting because, most lawyers may talk about, oh, you don't want to seek to recuse the judge. You may irritate them some. That is true. But I think the bigger risk for these Trump attorneys is by following kind of Trump's lead and making this very weak, attenuated recusal argument. What really hurts them isn't that Judge Chutkan is going to get mad at them. She's a very fair jurist. I used to practice with her when she was a public defender. No, the problem is they're going to lose their credibility. Right. She's going to feel you're willing to make any old argument, and that really hurts the attorney in court.
Yeah, reputational capital. It's a thing you draw on, right, over the course of a long trial. And of course, we expect they'll appeal. We'll see what happens. It doesn't look very good in terms of the grounds of that. We'll see what happens. Shan Wu, thank you very much.
Good to see you.